effect, Your Honor, I want to say that I'll be relying on the authority of Oscar Sudi, that is Criminal Revision 208 of 2020. I'll equally rely on Section 2 of the Porter, Section 5, Section 33, and friend Mr. Mburu to distinguish the authorities. You know, yesterday we were treated to a seekers by a man who never wanted to be referred to as a witness. Yes, you know? Mr. Mburu, to distinguish the authorities. The one you give actually, I'll share. You know, yesterday we were treated into a serious seekers by a man who never wished to be referred to as a witness, but who had nevertheless deposed an affidavit. The affidavit, Your Honor, on cross-examination, when put to cross-examination as to the content and the truthfulness of his statement, most importantly captioned under paragraph 4 of the affidavit, he simply said that he was not at the scene. That is therefore to say the averments contained under paragraph 4 are not averments that were either perceived, seen, or heard by the witness. It therefore says, Your Honor, and goes without saying that that was pure hearsay, and the same is prohibited under Section 63 of the Evidence Act. The content of that affidavit, Your Honor, which forms the backbone of these proceedings, is that our clients were transacting with finances. In matter of fact, it says the first respondent was transacting monies to a person connected to an array of criminal activities. It clearly came out, and this evidence was not controverted, granted that the DPP waived their right to re-examine, that this is pure hearsay. And therefore, Your Honor, if ground 4 of the affidavit, which forms the backbone of these proceedings, therefore fails on account of the same being hearsay, how then can we probably say that the subsequent paragraphs of the affidavits, which are predicated on paragraph 4, would suffice, would succeed? Your Honor, we pray that the court does find that paragraph 4, which predicates the subsequent paragraphs, is hearsay, on the basis that the witness confirmed that he was not the arresting officer and he never saw or witnessed. Subsequently, paragraph 5, he cannot therefore attest whether the respondents were aboard that motor vehicle. He said that the first time he got into contact with the respondents was at Kibbe police station. How therefore can he say confidently and under oath that the respondents were aboard motor vehicle? No wonder, Your Honor, that is why they have brought the third respondent, who is a mere border rider. When they gave on further examination under paragraph 6, and the details captioned by the inventory, they never said that they recovered a border or a motorcycle in that motor vehicle, simply because there is completely no nexus between the third respondent, the second respondent, and the first respondent. And that is why the inventory does not indicate. That is why paragraph 4 indicates that the third respondent is a border rider who was perhaps in the frolic of his own, but fights himself before you, and whom the DPP want to be incarcerated for a presumption or speculation of an alleged offense. Your Honor, if paragraph 5 therefore fails, it follows therefore that paragraph 6 subsequently fails. The so-called inventory, Your Honor, that has been brought before you does not square out with the criminal procedure provisions. It does not square out with the police standing orders. This is not how an inventory in law is taken out. There is a statutory provision and statutory form of how an inventory must be taken. We are treated into a SICAS, Your Honor. You'll have the opportunity to analyze that paper, a mere A4 paper, inventory. If they intend to rely on it, no exhibit memo. How can this qualify into being an inventory under the Criminal Procedure Code? Is it true, therefore, that the witness and the investigating officer, therefore, could be a competent witness or competent investigator if he does not understand how an inventory is taken out? Number two, Your Honor, on that basis, paragraph 3 of the affidavit is interesting. That they seek to incarcerate the respondent so that they can investigate the offenses alleged under paragraph 3. Under cross-examination, and when the same paragraph 3 was juxtaposed as against paragraph 8, which my learned senior counsel addressed you on, is that paragraph 8 completely indicates that they are yet to form an opinion as to the charges they were to prefer. When he was put under further cross-examination, why or under which situation or circumstances or wisdom that he applied to bring the respondents before you, he could not answer. If they have not yet formed the opinion of the specific offenses to answer, why are we before you? Why are we before the anti-terror court? If this does not amount to weaponization, intimidation, and harassment. And therefore, if therefore that is a question, does that square out with the mandate of the ODPP under Section 4 of the ODPP Act? Are these some of the cases that can be said that we are pursuing this for public interest? If the ODPP would come before you, and of course we understand the reason why this affidavit is this nature, it was prepared and the application was prepared at that point by the investigating officer. If they have not yet formed an opinion of what the offense is, may be accruing from the circumstances, why were the respondents not taken to Milimani law courts? Why were they not taken to Kiambu law courts? Why were they not taken to Ruto law courts? Simply because this court is being invited to getting into an arena or to uncharted waters of political weaponization. And political weaponization when the people are in pursuit of their rights under Article 37. Why is it important, Your Honor, under Article 37? Because the circumstances under which this case finds itself accrued and or arose during those circumstances. One, on the 25th of June, 2025, and on the 7th of June, Sabasaba. All those circumstances were when the people were exercising their sovereignty under Article 1 of the Constitution. And that is why my learned senior counsel to the court to look at, again, paragraph 6, where they are speaking about the diaries, and my learned friend has ably addressed you on it. The same was not even brought before you. The excerpts of the dates of interest, the dates that are of interest, and that's the reason why a diary is available, were not brought before you. The names of the individuals who are purportedly under investigations are not even known other than the name of Evans Njiru alias Balala. On further cross-examination, whether there is a complaint ensuing therefrom, when is the question of a compelling reason an issue? Is the test of the compelling reason applicable during the circumstances as we are faced, or they are applicable during the application for bail or bond? Could we all be wrong? I submit that the test of a compelling reason are not applicable in the circumstances. What is in issue is not an application for bail. What is in issue is the curtailment and the limitation of the rights of the respondents. We shall come to that question of the test. And therefore, Your Honor, before I tell you, I address you on the question of the test as laid out in the case of Oscar Sudi. The DPP or the prosecutor must understand the test applicable. The test applicable is a test as indicated by Justice Ngugi in the case of Oscar Sudi. Paragraph 9, Your Honor, of the affidavit. Again, they were not to specify with certainty, clarity, and conscience. And Jerry, help me. Not conscious. Yes? Briefly, sorry, I'm from Kirinyaga. Concisement, where they are interested in. Jerry cannot help me, and she's my women rep. They cannot. They could not specify with certainty which areas they are interested in. They say they are investigating Nairobi, Central, and Eastern region. For purposes of record, there is now where in our law that a place called Central is known. You look at the second schedule to the Constitution. We have counties, Nairobi or Eastern region. And there cannot be an invitation to presume that the investigator is addressing counties within the Central. He has indicated that he wants to investigate a region that is not known in law. Number two, Your Honor, even if we were to assume that they want to investigate the counties within the what used to be the former Central region, which county are they interested in? There are over 10 counties within that region. And then again in Nairobi, where are they exactly interested in? Which building, which street? Where is the specificity of these? So that then you can say when we release them that they will then interfere with that evidence somewhere in Nairobi. This is what we are calling fishing expedition, the embarrassment of the ODPP. You know, further to the issue of cyber forensic analysis, the witness confirmed and the DPP has admitted that there is no possibility that the respondents would interfere with the forensic investigation being undertaken at the DCI headquarters. And then even if we were to assume that there would be interference, then what is the integrity of the process? Who should protect that integrity? The respondents? How would they protect it? It is within their armpits to protect the integrity of that process. Permit me, therefore, to draw your attention, as I come to conclusion, to the test that was applied in the case of Sudi by Justice Professor Ngugi, as he then was. He applied two tests at paragraph 24 and paragraph 24. He says the first, so even while accepting that the text of Article 49, Clause 1, Paragraph F, may in certain circumstances and contexts comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reason for the continued detention through the state, application to have him held by the state must satisfy a double test. The first test, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to the existing exceptional circumstances. That is the first test. The test is not that of a compelling reason. Number two, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial. One, the interest of the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interest of the victims of the crime where appropriate. That is the test. We urge you, Your Honor, to rely on this test and disregard the test proposed by the ODPP. When you retire to make your findings, Your Honor, I would invite you to look at paragraph 27 of the same, of the said ruling, 28 and 27 and 29. But of most important is paragraph 29 from be to state that, and remember, this is a case, Your Honor, just to contextualize it. By the time this ruling was being delivered, Oscar Sudi, who authorized the arrest of the respondent, was a serving member of parliament. To say the state made no efforts whatsoever to demonstrate which witness would be interfered with and how such interference would happen at the investigation stage, given the offense contemplated. What this ruling, sorry? Paragraph 29, Your Honor. Paragraph 29 is speaking to the question of the interference of the witness. First, the argument the applicant is likely to interfere with witnesses because he is a man of immense persuasion and influence seems eminently pretextual for at least two reasons. You'll see that the question of the social status and social standing of an individual cannot be the test upon which, or cannot be a ground upon which an application such as this one ought to be admitted. The High Court is saying that you cannot simply say that Honorable Mukunji, who is a member of parliament for Manyata, has the capacity to interfere with everybody in Nairobi, even witnesses that he does not know in Central Province, witnesses that he does not even know or disclosed in Eastern Province, just merely because he's a member of parliament. The court is saying that is not the test. That is not the ground. And suffice to note, Your Honor, that do you understand why the second respondent is before you? The description given by the IO is that the second respondent is a journalist. For the mere fact that the second respondent is a journalist, he finds yourself before you. What is that the state did not want the journalist to cover? What is that they never wanted the journalist to expose? And is being a journalist a crime? Is it why the state was ordering for the closure, arbitrary closure of the media? And you know why the journalists were on the street that day, Your Honor? It's because the court rose up to the occasion to defend our democracy, to defend our constitution, to defend our rights. That is why the second respondent was on the street on that day. Otherwise, he would have been at home had it not been for the judicial power. What am I saying, Your Honor? I am saying that you have the power and the authority to rescue the country from this trap of political intimidation, political harassment, and political manipulation. Finally, Your Honor, I did indicate to you that I would address you on paragraph 5 of the Porter.
No, just to indicate that time has lapsed. We are now beyond the 1 hour that we.
How does that prejudice the DPP?
Yes.
I'm just about to finish. Your Honor.
We have other matters that we have to deal with. We don't want to find ourselves in a situation that we found ourselves yesterday. It is the court's time. Court is controlling time.
Your Honor, I am most obliged by the protection granted by the court against the tyranny of the DPP. Your Honor, paragraph 2 of the Porter has indicated that has given or listed the properties that are capable of being applied towards the commission of a terrorist act. Paragraph 2. Section 2, that of the Porter, the definitions. One of those is the funds. The application before you is predicated on the availability of the funds. Therefore, if the inventory, the purported inventory, and I have to rely on it for lack of otherwise, as embarrassing as it is, if there was no funds that were captioned by the inventory, where are the funds? Who took them? Why did the IO take the funds belonging to a crime? Why has he interfered with the integrity of that crime, if it was otherwise committed? The absence of funds in the inventory can only communicate the lack of good faith in these proceedings as elucidated in the case of Oscar Sudi. There cannot be any other conclusion, Your Honor. Number two, Your Honor, permit me to address you on the question of the terrorist property meaning. Again, the meaning of terrorist properties. Terrorist property, again under Section 2, proceeds from the commission of a terrorist act, money or other properties. If money is lacking, they have not said that the member of parliament identity card was an accessory of, or a tool of committing the crime. They have not told you the member of parliament's card that was a parliamentary card or his iPhone or anything were accessories. The case is predicated on the issue of money. And suffice to note, we have all agreed that the affidavit is laced and tainted with hearsay. Permit me, as I sum up, to address you on paragraph 33. Yes, paragraph 33. A police officer who detains, of most importance, Your Honor, because I know you refer to the law, is paragraph 33, subsection 2. Section 33, subsection 2. It will become relevant when you're making your decision. Equally, section 33, subsection 4, and subsection 5. That they are not compelling. The court is being told, a court shall not make an order for the remand in custody of a suspect under subsection 4 unless there are compelling reasons for believing that the subject shall not appear for trial. But this compelling reason is not at this stage. It's when the trial itself has commenced. That's the distinction I wanted to make. Paragraph section 35, on the circumstances under which the limitation of rights can ensue. Section 35, of most importance, is section 35, subsection 2, paragraph A, B, and C. Those are very important, and also subsection 3 of section 35, subsection 3. We urge you, Your Honor, to find that there are no reasons that have been brought before you. The same has failed to meet the test under the case of Oscar Sudi, and that this application ought to be dismissed and the respondents be set free. Your Honor, the respondents, but I shall make that application after you have made your decision. Again, permit me to just go slightly backwards. In the case of Oscar Sudi, again, look at paragraph 23 of the said authority and say what the judge is saying. 23, Your Honor. This is an act in futility. The application is meant to silence the dissidents, individuals who may not agree with the current existing status. Is a political persecution. It will almost amount to a detention without trial if the trial is based on speculation or the presupposed trial is based on speculation. Kindly put a lot of weight to the evidence that came out during cross-examination and the inability of the witness to answer the questions as put to him by the defense. Permit me to invite Mr. Moro to distinguish.
Before that, Your Honor,
sorry,
I have 4 points.
Just 1 minute.